Beside the decision in the South African case of Minister for Health, and another versus the Nucleus South Africa, where the South African court held that the principles of fairness are not to be applied by rote identically in every situation. It cannot be expected of the lawmaker that a personal hearing will be given to every individual who claims to be affected by the regulations that are being made. What is necessary is that the nature of the concerns of different sectors of the public should be communicated to the lawmaker and taken into account in formulating regulations. End of quote. Public participation does not necessarily mean that everyone must express their opinions. Instead, there should be tangible evidence of a purposeful initiative to incorporate a variety of perspectives in the participation program. This was asserted in the case of Moi Coal Basin versus Coal Basin local community and 15 others versus the Permanent Secretary, Ministry of Energy. And we cite a quotation where the court said public participation does not dictate that everyone must give their views on an issue of environmental governance. To have such a standard would be to give a virtual veto power to each individual in the community to determine the collective affairs. The question that must be answered by this court is whether an opportunity was afforded to the public to air their views on the implementation of the Affordable Housing Act. This is as per the threshold set by the decision of the Supreme Court in the case of British America Tobacco, PLC, versus the Cabinet Secretary for Ministry of Health, Kenya Tobacco Alliance, and another, and Mastermind Tobacco, where the Supreme Court in this decision said that, and I quote, public participation has been entrenched in our Constitution as a national value and as a principle of governance under Article 10 of the Constitution, and is binding on all state organs, state officers, public officers, and all persons whenever any of them A. applies or interprets the Constitution, B. enacts, applies or interprets any law, or C. makes or implements the public policy decisions. As aptly stated by the Appellate Court, public participation is anchored in the principle of the sovereignty of the people that permeates the Constitution, and in accordance with Article 1.4 of the Constitution, is exercised both at national and county levels. The court went further to reiterate this principle in the case of Aura versus Cabinet Secretary, Minister of Health, and the National Assembly has argued that the invited members of the public to take part in the exercise, which was conducted by the Joint Committee of the Department on Finance and National Planning and the Departmental Committee on Housing and Urban Planning, Public Works and Standing Committees on Roads, Transport and Housing, respectively. Both committees have demonstrated through their reports annexed as SN1 to the affidavit of Samuel Joroge, the clerk to the National Assembly, and JN1 to 3 of the Senate that support the assertions that the public and various stakeholders were invited and their views were taken into account before Affordable Housing Act was enacted. Herein below is a chronology as enumerated by the two affidavits that initial reading and committee referral that the Housing Bill number 75 was introduced to the National Assembly on the 7th of December 2023. The bill was subsequently referred to the Departmental Committee on Housing, Urban Planning, as well as the Departmental Committee on Finance and Planning. That on the 9th of December 2023, the clerk of the National Assembly published a notice in the local newspapers inviting the public to submit memoranda. This notice was issued under Article 118 of the Constitution and Standing Order 127 of the National Assembly Standing Orders, which require the House committees considering bills to facilitate public participation. That the National Assembly reached out to key stakeholders, inviting them to participate in public hearings held across the 19 counties on various dates, and this was not the only form of public participation, as there was nationwide collection of memoranda and public meetings in chambers of both houses. That from the 9th to 16th of December, the National Assembly collected public memoranda, which was collected nationwide. During this period, Petition 103 of 2023, that's the appeal case, was filed, leading to an order from the High Court in Kisumu prohibiting public participation as prescribed by the published notice on the 9th December, pending the determination. Subsequently, the High Court in Kisumu temporarily halted the collection of public memoranda, but this did not stop the other forms of public participation which were ongoing. On 17th January 2024, the High Court clarified that its order applied only to collection of memoranda by the National Assembly. On the 29th of February, the High Court in Kisumu ruled that the notice issued by the clerk of the National Assembly was valid, dismissing the petition. The court affirmed that the National Assembly had conducted public participation in a constitutionally compliant manner. This determination by a court of concurrent jurisdiction found that the National Assembly carried out public participation in accordance with the law. Based on the court's decision, it was concluded that the public participation, that is in the Kisumu case, had been properly conducted. We note that on the National Assembly extended its invitation to stakeholders through letters dated 11th, 13th, and 29th January 2024, requiring them to make oral presentations before the committee. These sessions were held on 29th and 30th of January 2024, as well as 6th and 7th of February 2024. We further note that the National Assembly that held consultations with various government agencies, including the State Department of Housing and the National Treasury and the State Law Office, offering opportunities for them to submit representations to the Joint Committee. This is to be found in the affidavit of Samuel Njoroge, Clerk of the National Assembly. The National Assembly then reviewed the written memoranda submitted by the public and invited stakeholders. A report detailing this consideration was annexed to the affidavit of the said Samuel Njoroge and marked as SN1. The bill underwent the second reading on 15th February. During that time, debate by members of the National Assembly took place, discussing the nature and effectiveness of public participation. The Assand report, which is annexed to the pleadings, details a report of the session of 15th February, which is attached to the pleadings here as SN2, and the documents this discussion. The bill was passed with amendments on 21st February and subsequently referred to the Senate in accordance with Article 110 of the Constitution. We also note that in line with Article 118 of 1B of the Constitution and Standing Order 145 of the Senate Roads, Transport and Housing Committee invited the public to submit written memoranda. This invitation was published in the Daily Nation, the Standard and the Star newspapers on the 23rd February 2024. These submissions were annexed to the pleadings and marked as JN1 to the Senate's response by an affidavit by Jeremiah Nyengenye, Clerk of the Senate. We note that the Senate conducted, through its Committee of Transport, Housing, and